Stuck, I just can't seem to take a hold of sights or sounds or places. A God I know the face of, still untold. Go on, hold me. Go on, hold on, beautiful. Witness what I listen. There's a world here you're missing to behold. A fiery night under the skies to warm your heart and hide away the cold. Venture out a little further, and somehow you might find the courage to go. 'Cause if you stand there long enough, you will realize you're really on your own. Go on, hold me. Go on, hold me. Hold on, beautiful. This time, be my only girl. We could undress all the world. I'll unearth your things, then you'll see. Go on, hold me. Go on, hold me. Hold on, beautiful. Go on, hold me. Go on, hold me. Hold on, beautiful. Did you ever think the earth would shake for me once more? I wanna see the sky light up over this city left for poor. Everybody's screaming, no one here can ask what for. And I just can't shake this feeling.
Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. You, our dear audience members at these National Constitution Center events, are congregants in this temple of reason. And therefore, yes, indeed, we need to inspire ourselves for the constitutional debate before us by reciting our congressional mantra. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis, and here's the second part, in order to increase awareness and understanding of the Constitution among the American people. That is what we are doing. That is why you have gathered here today, to educate yourself about one of the most fascinating and important Supreme Court cases of the year, involving fundamental questions of free speech and religious liberty. We have an amazing panel to educate and illuminate this question, and I know we're going to have a great debate. And I need to encourage those of you who are not yet members of the National Constitution Center to join, because then you will have first access to these incredible programs that we have coming up for the winter season, including in the next few weeks. Mayor Michael Nutter, interviewed by CNN's Michael Smerconish. A retrospective about the legacy of the late Justice Antonin Scalia with his leading law clerks and authors and supporters and critics. Then a conversation with Justice Ruth Bader Ginsburg, celebrating her 25th anniversary on the Supreme Court. It's going to be an amazing evening. And then, no less thrilling, a conversation with Judge Douglas Ginsburg interviewing me about my riveting new book on that underappreciated constitutional hero, William Howard Taft. What an evening that is going to be, and I hope you will be able to join us for that. And conversations with Yale Law School Dean Heather Gerken, historians Joseph Ellis and John Meekum. It's going to be a constitutional feast. All right, it's now time to introduce tonight's program, bringing together leading thinkers about this question of how to balance free speech and religious liberty against equality in one of the biggest Supreme Court cases of the term, masterpiece Cakeshop versus Colorado Civil Rights Commission. I'm so excited that our partners for this event are Spiked magazine, and Spiked will be represented by Brendan O'Neill, its editor-in-chief. Spiked is a superb magazine. It describes itself as a political magazine devoted to radical humanism and libertarianism. It is hard to categorize politically, but it is fierce in its defense of individual liberty. And Brendan is a distinguished commentator who is the author most recently of A Duty to Offend Selected Essays. And he will be joined by Stephanie Barclay, counsel at the Becket Fund for Religious Liberty. During her time at Becket, Stephanie has defended a young Muslim woman discriminated against in her employment, the Little Sisters of the Poor before the U.S. Supreme Court, and other practitioners of religious liberty. And finally, Paula Greisen is a partner at King & Greisen LLP. She's one of the attorneys who represented the gay couple in this case, starting at the trial level. She has been working with this case for 6 years and was a finalist for the CTLA Case of the Year Award for her work on behalf of the plaintiffs in Craig versus Masterpiece Cakeshop. Please join me in welcoming Brendan O'Neill, Stephanie Barclay, and Paula Greisen. Wonderful. When we have formal debates at the Constitution Center, we vote before and after. And because this is a case which is going to be decided by the court, I'd like to have a vote. And I'm going to state the constitutional question, and I want you to vote not for the side you want to win politically, but for the side you think should win constitutionally. In other words, separate your political views from your constitutional views. You could think it's really unfair for the gay couple in this case not to be able to get the cake, but that the Constitution protects the baker's right to refuse to sell it. Or you could think it's fine for him to refuse to sell the cake as a policy matter, but the law requires it. So the question that I'm asking you to vote on is, does the Constitution protect the baker's right to refuse to sell a cake to a gay couple? In particular, do the religious freedom and free expression provisions of the First Amendment protect the baker's right to refuse to sell the cake to the gay couple? We're going to vote now, then you're going to hear the debate. I want you to listen to it with an open mind. At the end, we're going to vote again, and the winner will be not the numerical winner, but the side that shifts the most votes. So I really want you to keep an open mind as you listen to this debate. All right, this is the question. Does the Constitution, does the First Amendment to the Constitution protect the baker's right to refuse to sell a cake to a gay couple? Who believes that it does protect his right?
It does?
It does protect his right to refuse to sell the cake. And who believes it does not protect his right to refuse to sell the cake? All right, a strong majority before the debate in favor of the gay couple on constitutional grounds. We have no better person to start us off than Paula Greisen, who's been representing the couple in this case for 6 years. Paula, why don't you start us off by stating the facts of the case, as they say in law school, and then defining the two constitutional issues, the religious freedom issue and the free speech issue, for our audience.
Okay. Hi. As a trial lawyer, it's very hard for me to sit down and talk, but I'm going to try. This case is about a couple, Charlie and David. They actually got married in Massachusetts because at the time Colorado law did not recognize same-sex marriage. They were planning a wedding celebration in Colorado, Lakewood, a little town outside the proper Denver area. And their wedding planner said, go to Masterpiece Cake Shop. They make really nice cakes there. So Charlie and David, along with Charlie's mom, Debbie Mum, came in from California. They were really excited about going and ordering a cake for their celebration. And they got some ideas together in a little folder and walked into the cake shop, Masterpiece Cake Shop, and sat down at a table, the three of them. And Jack came up and, what can I do for you? And they said, well, we want a wedding cake. And Jack's response was, for who? And it was pretty apparent. Charlie and David were sitting there. They're a very loving couple. It was pretty clear. The cake was for them. And they said, it's for us. And at that point, Jack said, no, I don't do wedding cakes for same-sex couples. And there was a stunned silence. And Charlie and David kind of looked at each other, and they stood up along with their mom, Debbie, and walked out of the store. Got in the car, and on their way home, Charlie started to cry. And David got upset that Charlie was upset and went home and put it on his Facebook page. Can you believe this happened to us? We just wanted a cake. And that started what you all know eventually landed in front of the Supreme Court. The next day, Debbie was very upset, and so she called Jack and said, why did you do that? Why did you refuse to make my son a wedding cake? And Jack, again, said, I don't believe in same-sex marriage. Same-sex marriage isn't legal in Colorado, and it was against his religious beliefs. And from that Facebook page, it kind of went viral. And the support poured out for Charlie and David, and a lot of support came out for Jack, too. And that's how we then found ourselves. Charlie and David were encouraged to file a complaint with the Colorado Civil Rights Division. They did. The Colorado Civil Rights Division agreed that there was probable cause to believe discrimination based on sexual orientation, which is a Colorado state statute, had occurred. And at that point, the commission then took it to a hearing. I represented Charlie and David at that hearing, and we won at the hearing. The baker then appealed it to the Court of Appeals. We won at the Court of Appeals, and the baker and his lawyers appealed it to the U.S. Supreme Court, and that's where we are now.
Wonderful. Thank you so much for that very helpful statement of the facts. Stephanie, do you have anything to add?
Sure. And first, Jeff, thank you for having me, and thank you all for being here tonight. I'm, as you mentioned, from the Becket Fund, where we defend religious liberty for people of all faiths, from A to Z. We like to say, from Anglican to Zoroastrian. I can't tell you how glad we were when we got that Zoroastrian case, because before then it did not have the same ring to it. And first, I think it's fair to acknowledge that this is a tough case. This is a case where there are deep feelings and hurt feelings and important interests going on. And I think that's why sometimes it can be difficult to talk about, and I'm so grateful for the National Constitution Center for having this important dialogue. So Jack, like many business owners, made a decision about what sort of message or event he wanted to support. And I'll talk about the facts of that a little bit more, but I think it's important to step back and think about the ways in which, in our society, Business owners and individuals make these sorts of decisions all the time. Recently, there was a gay coffee shop owner in Seattle that asked Christian individuals to leave his premises when they had been advocating for pro-life principles that he disagreed with. Chipotle, not too long ago, decided that they didn't want to cater to the Boy Scouts because they disagreed with the Boy Scouts' then position on their gay scout leaders. In Colorado, there were gay bakers who were asked by a Christian client to bake a Bible-themed cake that condemned homosexuality. And those bakers said, no, we don't want to create a cake that expresses that message. And in their scenario, the Colorado Commission said, that's right, you have the right to object to create something that is a message that you disagree with. In Jack's case, he has said, and the evidence on the record that's undisputed that was before Colorado and went up to the Supreme Court, he is willing to sell anything off the shelf in his business to anyone. And he would have been willing to design all sorts of cakes for this couple, but he couldn't create a custom design wedding cake for an event that goes against his deeply held religious beliefs. And by the way, that's not the only type of cake Jack won't create. He wouldn't create a cake celebrating racism, divorce, alcohol. These are cakes that he's actually declined in the past. And so I understand that many people in this audience, and in fact I saw by your votes, probably disagree with the choice Jack ultimately made about what message he should support and whether or not he should use his talents in that way. But that's not really the question in this case. The question is, do we want to give the government the power to make decisions about important, sensitive moral issues like sex, religion, and politics, and do we want the government to be the one that gets to say who's right and who's wrong, and that if you disagree that you can be punished? And that's what's at stake when the Supreme Court is going to decide this case.
Great. Well, we've had the facts and a sense that the issue is truly joined. Brendan, you are a defender of individual liberty and a vigorous defender of free speech. We'll wonk out on the technical details of the free exercise and First Amendment claims in a second, but how do you see the liberty issues in the case, and who do you think on constitutional grounds should win?
I think it's actually, in my view, it's fairly straightforward. I know the ins and outs of the case are quite complex and it will go on for a long time and has gone on for a long time. But I think the way I see it is that a business or an individual cake maker and so on should not have the right to refuse to sell his goods to someone because of their sexual orientation, because that would give rise to discrimination across society potentially, and then a certain section of society would be unable to access goods and services in the same way that other people could, and that's wrong. However, an individual business and an individual cake maker in particular in this case, who describes himself as an artist, should have the right to refuse to express something that he doesn't believe in. So if he had said to this couple, I'm not selling you a cake because I hate you people, that to me would have been a straightforward instance of discrimination and would have been unacceptable and unconstitutional and illegal. But what he's said is, I'm happy to sell you a cake, I'm happy to make you a cake, but I cannot express support for an institution that I don't believe in. I cannot say, whether it's with words or images or with my artistry as he views it, I cannot say that I support gay marriage. And I think we have to defend his right to refuse to say those words. And I think the reason I'm saying that is pretty simple. We have to reckon with how terrifying and unspeakable, in fact, it would be if the government could compel you to say something that you don't believe. If the government could make you express something that goes against every core of your belief system and every value that you hold. That is the first step, in my view, towards tyranny. And I think that would be a far worse outcome than the fact that this couple were incapable of getting a wedding cake from a particular shop. In my view, the fact that they couldn't get the cake there, but presumably there are many other places where they could have got the cake, is not particularly nice, and I'm sure they were upset. But if we have a situation where the government can force individuals to say things they don't believe are true, or to partake in ceremonies they think are wrong, or to express views that they think are repulsive or horrible or disgusting, which many of you probably disagree with them, but if we have a situation where the government can make people do that, then we no longer have freedom of speech, and we no longer have freedom of conscience. We have government-mandated correct thinking, which anyone in this room could potentially fall victim to and be made to say things that they don't believe. And I think that is infinitely worse from the perspective of liberty and choice and an open society than the fact that this couple, unfortunately, couldn't get a cake from this guy.
Can I
So
respond
thank you.
to that?
Please do. And Brendan has put on the table with admirable clarity his view that to force the baker to sell the cake would be a form of compelled speech. So, Paula, if you could, let's focus on this compelled speech issue, which is one of the two constitutional issues in the case. The Trump administration has taken a position similar to the one that Brendan just embraced, that someone cannot be forced to participate in an expressive event and to utter sentiments with which they disagree. So describe as precisely as you can, Paula, what the compelled speech claim is, and then talk about the cases and why you think it's wrong.
I'm a trial lawyer. Very rarely am I succinct, but I will try. First, I think it's important when you talk about these cases, facts do matter. And the facts here are really important. In the example that Stephanie used about the baker who would not bake a cake that had essentially hate speech on it, this was a baker who was asked to make a cake in the shape of a Bible. She agreed. She had no problem with doing that. After she baked the cake, the customer then said, I want you to take the icing and write on the cake, God hates gays. And she said, I won't do that. I find that offensive. You can have the icing piping, and you can write it if you want, but I'm not going to write those words for anyone on that cake. That's a big difference between asking for a cake and asking for somebody then to write a hate message on the cake. The issue here isn't whether the government is compelling Jack to say anything, the baker in this case. In our society, we regularly regulate commercial activity. The law at issue here just says to people, you can't discriminate amongst your customers when you sell something. It's not telling Jack what to say or what to think. It's letting Jack express his religion, and we all clearly know what he believes, and I believe in the First Amendment. The law here isn't doing that. This law is a general applicable law that's neutral. It doesn't target speech. It doesn't say you must send this message or you must send that message. It's just that when we have commercial activity in this country, we've decided as a nation, and Colorado as a state, that we're not going to let you pick and choose your customers, that there's something fundamentally wrong with that. And that's what this law is saying. It's not saying you can or you can't say anything. It's simply saying you've got to sell to protected classes across the board.
Thanks so much. So as you respond, Stephanie, describe as precisely as you can what the First Amendment expressive claim is and why it would protect the baker in this case, but not allow makeup artists or jewelers or wedding invitation designers, which were the examples that came up at oral argument, to refuse to participate in weddings as well.
Paul is right that facts matter, and in oral argument, one of the facts that the justices were really disturbed by before the Supreme Court is that, in fact, Colorado's rule would require Jack to write words on a cake that he disagreed with. The attorney for Colorado admitted that under the rule that they're advocating and the ruling of the lower court below with Colorado, Jack would have to create a cake that says, God bless the union of this couple, whoever their names are. He would have to write words on a cake that say any number of things endorsing a same-sex marriage if he'd write anything remotely similar for another event. So the idea that words make a big distinguishing factor between Jack's case and another case is contradicted by the record and what the Supreme Court found. But beyond that, in our country, we recognize that a lot of things count as speech that aren't just actually words that you write down, and I think that that's a good thing. We say that speech includes things like burning flags and the color of an armband that you wear in protest, and sometimes even really hurtful and offensive things like a Nazi protest that the Supreme Court unanimously upheld. And in this case, a symbol of, for example, the rainbow cake is what the couple ultimately received for the cake that they used in this case. And that means that gay bakers or a Black Lives Matter supporter baker could be forced to bake a cake with a Confederate flag-themed symbol on it for the White Aryans Nation Church if that was requested, because that's a protected classification under Colorado's law as well. And so we're absolutely dealing with a situation where all sorts of individuals could be forced to express something that they disagree with, which both triggers free speech protections and also triggers, in this case, religious freedom protections. And one thing that Justice Kennedy pointed out in this case is that, look, tolerance is really important in our society, but tolerance has to go both ways. And Colorado was not very tolerant of Jack and his beliefs. And that's what Justice Kennedy said at oral argument. And if you think about Justice Kennedy and how he's been a defender of tolerance, and in his opinion in Obergefell, for example, where he vindicated the rights of same-sex couples, what Justice Kennedy was saying was the problem in that case is that the government was picking one right view of marriage, and they were punishing or excluding those who had a different view, in that case, same-sex couples. And Justice Kennedy talked about the fact that we live in a society where people of good faith have lots of different views about marriage and sometimes disagree on that fact. And those views are worthy of protection. The problem is when the government gets involved and picks the correct view and punishes someone. This case is exactly that scenario, but in reverse. And that's why there have even been gay business owners who have stood up for vendors in some of these cases and said, we remember what it was like to be the minority that was marginalized and treated poorly, and we don't want to have a government that can punish us for our views, and so we don't think we should give the government that power in this case.
Great. Let's take one more round on the free speech question before religious freedom. Brendan, the justices seemed to think it was tough to draw the line, and there were a lot of questions from Justice Sotomayor saying, what about the invite drawers to Justice Kagan saying, what about a makeup artist? And the lawyer said no, and she said, it's a makeup artist. They say that they're an artist. So how do you limit this to wedding cake makers and maybe photographers, but not include the guy who didn't want to sell barbecue to the African-American couple in the 1960s? And how would you state the principle? Because the government says you can't be forced to participate in the ceremony. Is that the place where the principle kicks in, or is it writing on the cake at the time you're making it? A lot depends on exactly how the free speech principle is stated.
Yeah, I think Stephanie's right that there are freedom of speech doesn't just cover words. There are many different ways in which you can express yourself. There are different forms of expression. You know, there's the right to silence, there's the right to burn flags, there's the right to, daub certain things that might not make much sense, but which express some visceral emotion. There are many forms of expression which don't come down simply to words. And I think it seems pretty clear to me that the creation of a cake, which might have a rainbow flag on it, or two male statuettes, or whatever else it might have on it, which expresses support and conviction in the institution of gay marriage, it strikes me that that is very clearly an expressive act. And we are facing a potential situation where someone will be forced to express themselves in a way that they don't want to do. As to where the line comes between, what is clearly a speech or expressive act and what isn't, I mean, that is a difficult area to decide. But I think a cake and wedding cakes are expressive things. That's why you have them. You don't have them just to eat. I mean, you eat them eventually, but they are a centerpiece. They are the centerpiece of a wedding in many instances, and they say something about the wedding. I was at my brother's wedding recently, and he has 2 children before he got married, which many people would frown upon, but on his cake there was a man and a woman and 2 children. on the top. So that says something. Now, I'm sure there might well be a baker somewhere in the world who would not like to make that cake because they don't believe in sex outside of marriage. Fine, they shouldn't have to make that cake. That's an expressive cake. It says something. It says something about values. It says something about morality. So I think it's an expressive act, and I think it's wrong to force someone to express themselves in a way that they don't want to. But one thing that I think is really interesting in all of these cases, and there have been some cases in Britain too. There was a case of a bakery in Northern Ireland which was taken to court in 2016 for refusing to make a wedding cake. There have been other cases in Europe as well. What I find really interesting, and I can't quite pin down what's going on here, is why it is that couples who have the inconvenience, I'm not doubting for a moment that it is inconvenient and possibly upsetting, that they cannot get a cake in a particular baker, why they don't go to another baker. Because the reason I'm saying this is an important question is because the majority of bakers will make a gay wedding cake. That's what we have in Britain, and I'm pretty certain that's the same situation here, that it's not difficult for a couple to get, for a gay couple to get a wedding cake. That's not a difficult thing. It seems to me, and this comes to the free speech question, it seems to me that there's a punitive element to some of this, where almost there is the idea that it's unacceptable for a bakery to exist which doesn't share the values of mainstream society. I find that slightly vindictive and almost veering on the edge of religious persecution, where you go looking for the institutions that won't serve you precisely so that you can turn this into a public incident or illegal incident. And we've seen that in Britain, where people are almost trawling for incidents of discrimination, which they can then turn into a public spectacle. I find that really worrying because for me it comes down to what are the moral consequences of the decision that gets taken in cases like this. The moral consequences of this couple not being able to get a cake in one bakery is that they will be inconvenienced and they will be upset, and we should not undermine that. That's a serious thing, but it can be rectified by them going to another place and possibly by them encouraging other people through social media or campaigning not to go to this bakery that really annoyed them and treated them badly. That could be the consequence of that. But the consequence of forcing every bakery in the country to say something or express something or do something that goes against every grain of their belief, those consequences strike me as far more dire. Because those consequences will be the boosting of government power over expression and the erasure of any realm, small realm, in which people can hold views which grate against the mainstream. And I think those consequences are far worse than the consequence of gay couples being put out because there are some bakeries that refuse to serve them.
Okay, I have to respond to that.
Please do respond. It's designed for a good response. And in the course of your response, if you could, please give the audience some case law, because you've been living with this case for a long time. One of the big Supreme Court precedents is the Hurley case, where the Supreme Court said the Boy Scouts can't be forced to allow gay scoutmasters to march in their parade because a parade is an expressive activity protected by the First Amendment. What's the relevance of that and other cases, and why don't you think they cover the First Amendment claim in this case?
Okay, I will get into some case law. First, I want to clear up a few things. When you talk about a cake being expressive, whose viewpoint is it expressing? The person who orders the cake is expressing their viewpoint. It was your friends who said, I want the couple with the 2 kids on the top. It wasn't the baker's viewpoint. It was the customer's viewpoint. The argument that somehow everybody at that wedding would think that a wedding cake created by Masterpiece Cakeshop somehow expressed the baker's viewpoint is one that I simply don't buy. It's the customer's viewpoint. And that's important. Then this other concept of convenience I find very upsetting. And I know that our editorials went down, and I said this in the editorial, but we don't make our constitutional laws based on convenience in this country. I mean, I don't think anybody here would have suggested that Rosa Parks just find another bus rather than move back a row or anything like that. And yes, maybe in Denver, somebody did, when they saw the Facebook, offer to make them a certain type of cake, which was not in their thought process initially. Maybe you could in Denver. But we have a lot of people in this country that live in small towns that don't have 50 bakers to choose from. And even if you do, what do we say to those people? Aren't we relegating them to second-class citizens to say, keep going door to door and find somebody that'll serve you? Almost so many commercial activities in our country are expressive. Think about a website designer. Can a website designer then say, you know what, I think women really should be in the home. That's my religious view. I'm not going to design a website for an all-female owned business. How offensive would we find that? An interracial couple walks into a photography school, a commercial business. Photography is clearly within the First Amendment. Can the photographer say, I don't believe in interracial marriage, therefore I'm not going to give you a service? This is the slope, but once we go down, start trying to pick and choose. In the Supreme Court, it was, well, a makeup artist isn't protected, a baker is, Michelangelo wouldn't be protected because they're doing it for a building, but a chef would be under certain circumstances. This is not a slope that we want to go down as a country, decide which businesses can pick and choose their customers. And in front of the Supreme Court, the court said, well, how is race different? How are you going to choose that you're just going to protect this religious tenement of this baker? And the answer was, well, race is different. We're not quite sure why, but maybe because there's so much historical discrimination. But every other group, they're fair game. So people with disabilities, veteran status, gender, all the other categories that we see as protected, those individuals can now be discriminated against in the name of religion, including religious protections can be discriminated now against in the name of religion. So, you know, the Supreme Court talked about this issue in Piggy Park back in the Civil Rights era when a barbecue restaurant objected to, did not believe in the intermingling of mixes and did not want to serve African American people in its barbecue restaurant. And the Supreme Court just said, no, that freedom of association, freedom of speech argument isn't going to fly. We will not constitutionalize freedom to discriminate in the name of protecting your First Amendment rights. And I think that's the precedent the court should continue. Look at this as regulation of commercial speech. The parade is different because that is it was a private expression of belief in Hurley, a private expressive activity. This is different. This is somebody who's supposed to be open to the public for business, and I think they should have to do so on a non-discriminatory basis.
So Stephanie, what do you make of that distinction that here the claim is he himself has the expressive right rather than the Boy Scouts who were a private association who had an expressive right? And why is race different? At the oral argument, the council conceded if the baker had refused to bake a cake for an African American couple, that wouldn't be permissible. Why is that the case constitutionally?
So I have three responses for both of these great points that have been raised. First, as far as expression goes, Paul is right, and you're right, Jeff, that sometimes it's hard to draw lines as far as when what you're doing is expressive enough and when it's not. And I think it's important to keep in mind that the Supreme Court and other courts deal with this question when it comes to expression outside of this hot topic all the time. It might be expressive when someone burns their flag in protest, but it's not expressive when that person burns their flag because they're just throwing it out in the trash. And so it depends a lot on the context and the purpose and what was understood by those actions, and those are always fact-specific questions. I think it's also important to keep in mind that in the context of a wedding, weddings themselves are deeply expressive events, and the Justice Kennedy and Obergefell talked about how important weddings are and how Americans should be allowed to make deeply personal decisions about whether they're going to participate or not. And even if we think about a cake at a wedding, I don't know about you all, maybe I'm just unlucky, but I've never been to a wedding where I thought, gee, that cake was delicious, and I just want to eat a lot more. I don't know if anyone else has had that experience And maybe if you won't raise your hand, it's because you're sitting next to someone who you went to their wedding recently. So that's okay, I understand. But I think we need to be honest about the fact that why do we all keep eating bad cake at weddings? It's because it's part of this ceremony and it's part of this tradition. It's really cultural. One sociologist called it the secular sacrament of our time. And the couples stand up together and they sometimes daintily feed each other the cake to show their commitment. Or if you're my husband, he shoves it as far up my nostrils as he can. And this is imbued with meaning and symbolism to us. And it cannot be the case that marriage and weddings matter when we're defending those rights to LGBT couples who want to participate in that. But marriage and weddings and ceremonies surrounded by them don't matter and aren't symbolic at all for someone who doesn't want to participate in that. So how do we draw lines, I think, is a question that a lot of the justices wrestled with at oral argument that we're talking about tonight. First, it's important to keep in mind that if it's expressive, or if we also have free exercise rights here, where it's Jack's religious beliefs, that's just the first part of the test. So it doesn't mean that just because someone has an expressive belief, then they get off scot-free and they can deny people for doing whatever they want. That just means that now the government has to prove that they have a good reason for trumping those First Amendment rights. And the Supreme Court has actually dealt with this conflict between public accommodation laws and between First Amendment rights on multiple occasions, going back for decades. And we have not resulted in this slippery slope scenario where we have had discrimination that looks again like the Jim Crow South. We've had nothing like that. Those cases still don't exist after decades of the Supreme Court balancing these important rights. Factors that the Supreme Court has looked at are, number one, how broad is the First Amendment objection? Is the person, in Hurley, for example, these were some of the factors they looked at. Is the objection just to a particular message, a really discrete event, but they're willing to include the individual or sell them anything else, in which case the government has a weaker interest there. The other factor that the Supreme Court looked at in Hurley, and Paula may not like it, but it is the law, is the Supreme Court looked at, is there some sort of a market failure here that the government has an interest in addressing? Is there a monopoly? Is there a wide swath of businesses that won't provide this type of service? The government has a stronger interest if there is. And here, in Jack's case, the government didn't introduce one iota of evidence about that, nor could it have, where there were bakeries begging Jack for their business and offering to provide, or not Jack, the couple, offering to provide it for free. So those are the factors that the Supreme Court has provided for us after something is expressive or religious freedom to decide whether or not those cases will be meritorious or if the government has an interest sufficient to trump the First Amendment. Because the First Amendment doesn't mean that we always win, but it means that we're not giving the government carte blanche power to decide what view is right for our society.
Great. Brendan, one last summation on the First Amendment question, and then we'll put on the free speech, and then we'll put on the religious liberty question on the table. There are a lot of cases bubbling up in the lower courts. In Kentucky, the state Supreme Court is confronting a Christian printer who didn't want to print T-shirts with symbols for a local gay pride festival. Should the printer be forced to create the shirts? A gay coffee owner in Seattle asked Christian customers to leave his shop because they'd been advocating for the pro-life movement. Should the coffee shop owner be punished? What's your thought on those two cases, and are you concerned about the difficulties that lower courts will have in drawing lines if this Pandora's box is open?
Yes, I would like to live in a society that can absorb cases like that and live with the fact that there will be a minority of businesses and a minority of individuals who sell things who will not want to express certain things or have people who express certain things on their premises. If this was a widespread thing, if this was a cross-American society or across British or European society, there would be a problem. But these are pretty small cases of individuals or small groups or small companies who don't want particular things to be said and done. And I think I think it's preferable for society to find a way to manage that situation than to invite the government to police who you must associate with, what you should express, and what you should facilitate other people in their expression of. I think that living with it is preferable to that, in my view. But there's a real contradiction in this particular case, because on the one hand, we're told that the couple were deeply upset, and I have no reason to question that. I'm sure it's true. They were deeply upset because the cake was incredibly important to them. It was a very important part of what they wanted and of their ceremony and of their life. But on the other hand, we're told, oh, it's just a cake. Why is this guy so upset about having to just make a cake? And I think that's a really interesting contradiction, because you're either saying that this cake is so incredibly important that you're going to go all the way to the Supreme Court in order that they can have it, which suggests to me that it's more than cream and jam and butter. There's something else going on here. It's a very symbolic, important, expressive thing. That's precisely why I think we have to try and have a situation where people can refuse in certain circumstances to express another person's point of view on their behalf in creating a product or creating something for them. But I really think it's incredibly important to challenge Paula's argument and this insinuation that anyone who takes the side of the baker in this case, or in other cases similar to it, is like the people who wanted Rosa Parks to stay at the back of the bus, or like the people who support discrimination against black people in diners in the 1950s and so on. No one here is defending the right of any company in America, so far as I know, to refuse to serve couples on the basis of their sexual orientation. No one is defending the right of any company in the United States to refuse to offer services or products to anyone on the basis of race, gender, orientation, and so on. Certainly I'm not. What we are saying is there are particular incidents where a service becomes an expressive product and it becomes problematic for a minority of people to take part in that. And that seems to me to be a very, very distinct from the kind of discrimination that was practiced in the past. And I think it really doesn't offer any clarity except to try and boost the moral authority of your side to try and conflate those two things. And just one final point, which we might come on to in the religious thing, is I think it's really worth thinking about the term discrimination, because we all think discrimination is a bad thing, and it can be a bad thing, but discrimination can also be a good thing. You can be a discriminating person. You can have a discriminatory taste in art, for example. And we have to remember, this is a point Hannah Arendt made in the 1950s, in fact, after some of the racial controversies. She made the point that freedom, the right to discriminate is absolutely essential to the freedom of association. And if you cannot, at some level, discriminate, particularly in private groups, not in public life, but in private groups, if you cannot discriminate, then you cannot have freedom of association, and that's a problem. But then she raised the possibility that between private groups, where there should be the freedom of discrimination, and public life, where there shouldn't, there is a grey area which we would be foolish to invite the government to police in the way I think this case is going to do.
Thanks for that, Paula. You may well want to respond to some of those last points, but then do put on the table the religious freedom claim. The First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the claim in this case is that the baker's rights to freely to exercise his religion are being violated when he's compelled to embrace a message with which he disagrees. Describe that claim and tell us why you think it's wrong.
First, I want to respond to the notion that this is about a piece of cake. It's no more about a piece of cake than Piggy Park was about a piece of barbecue, or that Rosa Parks was about a seat on a bus. This is about human dignity. And the reason why Charlie and David filed their complaint wasn't because of a piece of cake. It was about what it felt like to be humiliated and degraded and treated like a second-class citizen. So when we start talking about the humiliation and pain of discrimination, we can't trivialize it by saying, well, just go get that service someplace else. I think that's really, really important to this debate. Jack was the person who decided to continue appealing and appealing and appealing this, mainly, I think, because the issue of same-sex marriage is very divisive right now. If this was a Jewish person who walked in and asked for cupcakes for a bar mitzvah and had been refused, nobody in this room would have said that's okay. But because it's the issue of gay marriage, which is still very divisive, this has become a very polarizing issue that, in fact, I believe is a very slippery slope once we start going down it. The freedom of association argument that you referenced is the argument that was raised in Piggy Park. You're violating our free speech and freedom of association, the First Amendment, by requiring us to associate with the black people sitting at our counters. That is an argument that we have rejected as long as there is a governmental interest in the commercial regulation. Here, and I will disagree with Stephanie, I think Colorado argued very successfully, as most states in this country would argue, that the government does have an interest in eradicating discrimination. The Obergefell decision, which was referenced several times already, that Justice Kennedy wrote, talked about the historical discrimination faced by gay people in this country. And for over a century, we used to outlaw same-sex sex. We criminalized it. He chronicled, in addition, and Stephanie's absolutely right, he said it's very important to be respectful of religious beliefs, but this is a group that historically, as opposed to the characterization where it happens now and then, the discrimination against the gay community has been systemic in our country, has been fraught with violence and terror, and I don't think this is an isolated situation by any stretch of the imagination. So yes, we do need to be respectful of religion, and the Colorado State statute specifically exempts organizations or businesses that are primarily for religious purposes. So those businesses that operate primarily for religious purposes do not have to comply with this law, and I believe that's how we are respecting freedom of association and freedom of religion.
Many thanks for that. All right, Stephanie, let's really dig in on the religious freedom claim, which of course the Becket Fund is devoted to protecting. Describe the free exercise claim as precisely and constitutionally as you can. Tell us the relevant cases, and why do you think that those cases support the baker's right to refuse to serve the couple on religious grounds?
There's a lot of similarities here between the First Amendment rights for Jack's free speech protections and his free exercise rights. He's arguing that being forced to custom design something that he's creating that goes against his religious beliefs is something that the First Amendment prohibits. And Paula talked earlier about, well, it's not his message, it's the couple's message, and I think it's the couple's message too when they have a cake at their ceremony. But there's also, I think, something significant about just the act of creation. I think it would be significant if we force someone who believes in Black Lives Matter to have to create a Confederate flag-themed cake. That very act of creating something that goes against their beliefs, and I think is something that should be protected for them. And for Jack, part of what he's objecting to is also that act of being forced to create and design something that contradicts what he religiously believes in. And the way that the Supreme Court has protected free exercise rights is that they have said if the government is willing to provide protection to people for secular reasons, so if they're willing to protect the gay bakers in this case who didn't want to create the Bible cake that had a message that they rightly disagree with, I think that they rightly chose not to create that message and that cake, then it is a double standard, and it is constitutionally dangerous to not offer that same sort of protection to Jack. There's a couple other things going on here as well, in particular, that are relevant to his free exercise case and the level of coercion that the government is engaging in. And that is that it came up in oral argument that not only, if Colorado wins, if their order is the law, not only then would Jack be forced to create these kinds of cakes, and as we discussed, cakes that have words on them saying, I bless the union or celebrate the union of these other same-sex couples, but he actually would have to give training to his family employees about why his religious beliefs are incorrect and why the government...
No, I don't. I think he'd have to give training on the anti-discrimination laws.
And why those laws, and why his beliefs are, he's not able to carry them out before the business. That came up in oral argument. The attorneys for for Colorado admitted that he has to give that sort of training to his family employees. That's a really troubling level of government coercion in this case. Now, I want to go back to a few other things that Paula talked about with the Piggy Park case she keeps referring to. And that is a case where, in an unpublished per curiam decision in a footnote, the Supreme Court said that there weren't going to be attorney's fees for a business owner who said he was never willing to serve black people because of his religious beliefs. And I think it's important to think about the really shameful history that our country has of race discrimination and the Jim Crow South, and the fact that individuals in that era sometimes, when they traveled across the country, had to carry green books with them so that they knew where they could stop to eat and how they could even try and survive in our political and our economic society. And that's something that was a serious problem in our country, something that we created powerful tools to address through public accommodation laws. And no one disputes that if this was a case where Jack was saying, I'm not willing to serve LGBT people anything in my shop, I disagree with you as a class of individuals and I'm not willing to serve you, that would be a different case. Under Supreme Court precedent, the government would have a much stronger interest here. That's not what's going on. Jack is telling this couple, I'll design cakes for you for any other event. I will sell you anything in my shop. I just cannot create this custom designed message. And one last point to make is, I think it's absolutely fair to recognize the dignitary interests, and I don't think, no one I know is happy that this hurt the feelings of this gay couple, and I think we can certainly understand their feelings. But if we want to talk about dignitary harm, think about the Holocaust survivors in the Supreme Court case in Skokie. Some of these individuals still have tattoos on their body from the mistreatment that they received during Nazi Germany. All of the loved ones that they loved in some instances are gone, and they were arguing to the Supreme Court that their dignity should not allow Nazi protesters to come to their town. No one doubted that their dignity was at stake, and that was a deeply offensive thing that those protesters were doing. I think we can all agree is despicable and hateful, and we would never join that protest. But the Supreme Court unanimously protected First Amendment rights in that case, because the Supreme Court recognized that if we're not willing to protect freedom even when we deeply disagree and it is hurtful and offensive, if we won't protect freedom there, then we're not able to protect freedom for all of us. We live in a society where the government can take those freedoms away from anyone.
Brendan, on the religious point, are you moved by the religious claim independently from the free speech claim? How would that religion claim fare in Britain, which of course has no protection for religious freedom in the same ways? And then to put the first of our phenomenal audience questions on the table, should for-profit religious companies be required to list all activities that violate their free exercise rights, or do they decide on a case-by-case basis?
I'm really worried about the state of religious freedom in the Western world at the moment. I think we've become too cavalier about it. I think we've become too cavalier about the freedom of conscience, the freedom to believe and to act on your belief within reason, without ideally harming other people. We forget that much of the modern enlightened West is built on the argument for freedom of religion. And if that hadn't happened, then we wouldn't be in this room having this discussion now. It's an incredibly important freedom. And if you want to see a slippery slope, have a look at what's happening in Britain in relation to the application of equality legislation to undermine people's freedom of association, freedom of expression, and freedom of religion. Because once you go down this route of inviting the government to tell, firstly, companies, and then it could balloon into other groups as well. Once you invite the government to tell people that they must prioritize equality in all instances above their own convictions, then you open the floodgates to some pretty tyrannical behavior. In Britain, for example, the government's equality legislation a few years ago forced a party called the British National Party, which is a horrible racist organization, forced them to rewrite their constitution, which said that the party was only open to Caucasian people on the basis that it was it celebrated inequality. That is tyrannical. That is the end of freedom of association and the end of political organization, however much you might despise the British National Party, as I do. I've marched against it many times when I was younger. There have been other instances where religious groups in the UK and in other parts of Europe have been punished and in some cases given prison sentences for pushing inequality. So, for example, a pastor in Sweden was given a 1-month suspended prison sentence for describing homosexuality as a tumor on society. Now, we will all agree, I think, that that's a pretty repulsive view, but that is his deeply held religious view, and it ran counter to Swedish hate crime and equality laws, and therefore he was punished. A church in Britain was recently made to take down a poster warning passers-by that if they didn't believe in God, they were going to hell, because that was seen as harassing and alarming and making non-Christians feel humiliated and bad. And I personally think it's bad to base laws on what people feel rather than on the question of rights and liberty. So if you want to see a slippery slope, look at what's happening in Europe with the use of equality legislation to undermine freedom of religion and freedom of speech and freedom of association. Just one other quick point I wanted to make in relation to some of this stuff. I have to just reiterate how unhelpful I think it is that you are conflating the discrimination against black people, which was widespread and horrendous, with this case. As I've said before, I have never heard one person, not one single person, including Jack or anybody else, say that they want to discriminate against gay people and they want to stop serving or associating with gay people. And I genuinely believe that you risk minimizing the crimes of the past by constantly marshalling them to your cause, because you are suggesting that what Rosa Parks faced was similar to a couple who are incapable of getting a cake, when in fact what she faced was the denigration of her entire life and her entire being and her ability to go about her life unmolested and in any way whatsoever. And I think it's a profound problem to conflate those things. And in relation to the freedom of religion thing, the last thing I would say is that I'm worried about the way in which religious beliefs are now being redefined by some people as akin to bigotry. And if you hold a certain view on gay marriage and you think marriage is between men and women, and if you genuinely believe that, you are automatically branded a bigot. You are homophobic. Now, I come from a religious background. I'm not religious, I'm an atheist, but I come from a religious background, so I know lots of people who think that marriage should be between men and women. And I can tell you they are not bigots. They do not hate gay people. They simply have a religious belief about the institution of marriage. And I'm worried about the constant creeping redefinition of belief as hate crime, of certain convictions as a form of abuse or bigotry. And I think it's worth going back to the actual definition of the word bigotry. Bigotry actually means intolerance of someone who thinks differently to you. That's the meaning of bigotry. Bigotry doesn't actually mean racist or sexist. It can mean those things. But the dictionary definition of the term bigotry is intolerance of someone who has a different opinion to yours, usually a different religious opinion, if you go back to the early definition of bigotry. And I am worried about the way in which actually it's those who pose as warriors against bigotry in cases like this who are often enforcing a bigotry of their own through making it increasingly difficult for people with certain religious views to express themselves or not express themselves as they see fit.
Paula, you may want to respond to a bit of that, but we have about 5 minutes and all of these great questions, so I'm going to pose one of the questions to you as well, and it's a very straightforward one. Could you deduce anything from the Justice's question at the oral argument, basically based on the oral argument, how do you expect the court to vote?
All right, well, going back to Brendan's point, I believe in religious freedom. My mother is a very religious person. She's a Christian. She accepts gay marriage. I'm not saying her belief is right and Jack's belief is wrong. I think it's really interesting when we start trying to value the harm of discrimination between different groups. To say the harm of discrimination felt by African Americans is somehow more important than the harm felt by other religious groups or by groups based on sexual orientation. I mean, this country does have a very a very pronounced history. Anybody who knows the Matthew Shepard case and knows about that gay college student who was tortured because he was gay and tied to a fence and left to die, where he did 5 days later. It's not an isolated incident, and I don't think we can start calibrating whose harm to dignity is more real or more important than somebody else's. I am certainly not, and never have, questioned Jack's sincerely held religious beliefs. I applaud him, and I think he should be able to express them. And I'm not trying to conflate. I've never called him the name or denigrated in any way. Nobody has in this case. And certainly David and Charlie have never denigrated Jack's belief. The question is whether in a society that's a pluralist society like ours, if you're going to open up a business, private associations are different. Private parades are different. Writing pamphlets, I would even say, are different. But there's so many activities that are expressive. Once we start going down that road, you do open up the floodgates. We do have a Bill of Rights in this country. We do have the Equal Protection Clause as well as the First Amendment. So I'm not as worried. Most of the examples you hear about preachers or religious organizations, the law already exempts those organizations in our country. So I think religious freedom can sit side by side with the government regulation that if you're going to open for business, you're going to serve everybody equally. And I completely forgot what the other part of your question was, Jeffrey.
Well, then I'll pose it to Stephanie, because we should just
go ahead.
get it on the table. The commentary noted many people think the case is up to Justice Kennedy. This forces him to balance his commitment to equality for gays and lesbians against his passionate commitment to free expression and religious liberty, and he seemed to express sympathy for both sides in the oral argument. How do you think he's going to vote, and which way do you think the case will come out?
Yeah, it's a great question, and it was a really interesting oral argument. Justice Kennedy clearly cares about the dignity of this gay couple and gay couples and everywhere in all sorts of marginalized groups in society, and I think he takes that very seriously. And I also think that Paula is right that I don't think it makes sense in this case to act as though the couple didn't experience hurt, and that there have been times in our country where we have treated LGBT individuals terribly and where they have been faced all sorts of injustice. And so it's clear that that's on Justice Kennedy's mind. But what's also clear is that he understands that in a pluralistic society, we have to protect dignity on both sides. He also talked about Jack's dignity. I mean, there's another case, one of these vendors is a 70-year-old grandmother who, if she loses her case because she couldn't provide a custom service for a same-sex wedding, she will not only lose her business, but the state will come after her for millions of dollars. And I think the dignity of those people is on Justice Kennedy's mind. And that's why he brought up the importance that tolerance in our country needs to be a two-way street. And he also talked about some concerns that he and other justices pointed about in Colorado. Some of the statements by the commissioners below were quite hostile to religious beliefs and the place of religion in society, and sort of acted like, look, if you open a business or if you're coming out here, you shouldn't be able to have religious beliefs at all. You're going to have to compromise, and said some derogatory things about religion in general. And that seemed deeply troubling to Jack, that there seemed some sort of, or to Justice Kennedy, that there seemed to be animosity towards religion, and also that there was this double standard between how Colorado treated gay bakers but not Jack. So I think that that's going to be important. I also think that the Supreme Court precedent in the First Amendment area has generally been quite clear that while dignitary interests certainly matter and we don't want to minimize those, we have to look elsewhere when we decide whether or not the government has the power to force someone to express a message they disagree with or do something contrary to their religious beliefs. That's why the Supreme Court has protected the First Amendment in cases, we've talked about Skokie, they've protected protesters at funerals that said horrific things about those individuals going to hell, which also certainly hurt their dignity in that case. And the Supreme Court has said that we have to look to other government interests in order to decide whether coercion is warranted. And here, the government simply hasn't made a case beyond dignity why they're justified in taking away Jack's freedom. And again, I still haven't heard an answer why this case would be any different than if we were forcing a Black Lives Matter baker to create a cake that had a Confederate flag themed on it for the White Aryan Nation Church. You cannot give protection to that baker and yet not give it to Jack, unless we're going to live in a society where the rule is that we protect people we agree with and no one else. And that's no way to run a constitutional democracy.
Well, National Constitution Center panels, like Supreme Court arguments, have to end more or less on time, and therefore it is time for our final vote. Before voting, I want you to reflect very carefully about the constitutional arguments you've heard on both sides, approach them with an open mind, and now, having heard the arguments, please vote once again. Do you believe that the First Amendment to the Constitution protects the baker's right to refuse to sell a cake to the gay couple? Who believes that the First Amendment does protect the baker's right to refuse to sell the cake? And who believes that it does not? Who changed his or her vote as a result of the discussion? And how many people changed their vote from Paula's side to Stephanie's side after having heard the discussion? And how many people changed their vote from Stephanie's side to Paula's side as a result of the discussion? Oh, wow. This is an extremely imprecise tie, but I'm going to call it a tie. And I want to thank our panelists for this extraordinary discussion. Thank you very much.
Thank you, Jeff.
Wonderful job.